Modifying child custody or support orders in Massachusetts. What you need to know. Here's a simple way to understand what a custody or support modification actually means and why thinking your order is stuck forever is totally a myth. Okay, if you have a court order and you're thinking, this made sense back then, but it absolutely does not work anymore, you're not doing anything wrong by asking that question. I hear this all the time. Life changed, schedules changed, money changed, kids and their needs changed. But the court orders stayed frozen in time. That's where a modification comes in. Hi, I'm Lindsay Egan, owner and founder of Poppy Legal Group. I help people all across Massachusetts deal with custody, support, and post-divorce changes when real life stops matching that paperwork that you locked in so long ago. And today, I want to explain what a modification is and when it makes sense to pursue one. If this kind of clarity is helpful, follow along. I break this stuff down every week in plain English. Let's start here because this is where people start to get confused. A modification does not mean reopening your divorce or your case. It doesn't mean starting over from ground zero. And it doesn't mean the court messed up or you messed up the first time. A modification simply means asking the court to change an existing order because something significant has changed since it was put in place. In Massachusetts, the court looks for what is called a material and substantial change in circumstances. Clear as mud, which is just a fancy way of saying something important changed. It wasn't temporary, and the current order no longer fits real life. So as far as what kinds of things can be modified, people are often surprised by this part. You can ask to modify things like custody or parenting time, child support, alimony, certain parenting provisions. What usually cannot be modified is property division. That part of a divorce is generally final. So modifications is really about these ongoing obligations, not how assets were divided years ago. And as far as what counts as a real change, this is where people start to spiral and second guess themselves. And honestly, they shouldn't. Massachusetts law does not give a perfect definition of significant. And that's intentional. The court looks at whether something meaningful has changed since the last court order, not whether life is flawless. Because if it's like mine, it's probably not. Common examples of this include things like, a job loss or a major income change, parent relocating or changing their work hours or schedule. A child's needs change, school changes, health and development, they change, right? As kids grow in parallel to those changes and that aging. A schedule that worked when the kids were younger, but it doesn't now. Ongoing conflict or an order that sounds fine on paper, but fails in real life. Okay, so here's the deal. The judge is not asking, is this inconvenient? They're asking, does this order today reflect reality today? If the answer is no, that's usually enough to at least have a conversation. A question people ask a lot is, what happens if life keeps changing? There's not a strict time limit or limit on how many times someone can request a modification in Massachusetts. But each request has to be based on a real change since the last court order. Courts generally won't entertain repeated filings that are based on the same facts, and judges can dismiss requests that don't show a genuine change in circumstances. So, real talk about the process. Once that complaint for modification is filed, you're not signing up for instant court drama. The court is going to first look at whether that change is real and is ongoing. Then, whether modifying the order would actually improve stability for the child or family. Massachusetts courts are not supposed to favor one parent over the other. What they care about and should care about is whether the requested change makes practical sense based on how life is actually functioning right now. And Massachusetts handles modifications a little differently than other states. Many use the phrases material and substantial change in circumstances. And Massachusetts courts apply a similar concept. The judge is going to look at whether something meaningful has changed since the last order and whether updating that order would better support the child's stability and best interests. You're not failing because circumstances have changed. You're allowed to ask for an order that works with your real life, not the version of it from years ago. So, a quick Massachusetts reality check. In Massachusetts, you don't just call the court and explain this informally. The process starts with something called a complaint for modification. That is the legal filing, that paperwork that tells the court, this is what's changed and when, and this is what I'm asking for. The other parent is formally served. Yes, both parties have to be notified just like any other court action. And then the court decides how to move the needle forward. Sometimes that means there's going to be a hearing. Sometimes there's going to be some temporary orders in place. And sometimes it means some negotiations or discussions before we even put you in front of a judge. So it just depends on the facts, not just the filing. What this is not. This part matters more than people think. If the issue is that the other parent is not following the court order, modification is usually not the right tool. That situation is typically an enforcement or contempt issue, which is a different legal path with a different goal entirely. Enforcement is about getting someone to follow an existing order, not rewriting that order. And modification is not about punishment either. It's not about proving something or someone is wrong or showing the court who is more difficult. Okay, so here's the deal. The right tools depend on the problem you're actually trying to solve. If the order still makes sense, but is being ignored, enforcement is generally the move. If the order no longer fits real life, even if both parents are trying, that is when a modification comes into play. Using the wrong tool can waste time, money, emotional energy, and it can delay the outcome that you actually need, want, and deserve. This is not about escalating conflict either. It is just about choosing the process that fixes the problem that's right in front of you. So if you're sitting there thinking, this order does not fit or support my life anymore, you're not being dramatic, you're not being needy, and you're not behind. Modification exists because life changes. The question is not whether you're allowed to ask, it's just really, how do we do it strategically? If you want help figuring out whether a modification makes sense in your situation, you can book a consult online. You don't have to go through a million people, and we will talk through your options calmly and honestly together.